I commend this bill to the House.
The question is that the motion be agreed to. I call the honourable member, Jonathan Young.
Mr. Speaker, well, what an outrageous speech to bring out some of those claims and comments. Absolutely outrageous. You know, we understand in this Parliament, sir, that nobody supports harm that comes from gambling. We understand these things. But I wonder where that member's research comes from that says that casinos per se are major drivers of crime. That's what I say is outrageous. It's outlandish, some of those quotes and comments. Well, I live on a planet of reality, sir. And Mr. Speaker, we on this side of the House are not supporting this bill for some very good reasons. Now, we on this side of the House, we are committed in building a safer New Zealand. And I think New Zealanders out there in our country know that. When we have seen crime and criminal activity reduce in this country because of the legislation that we have put through this House, and have seen public confidence in our law-keeping forces rise and increase, when in past years under past administrations they decreased, I think New Zealanders know that the national-led government is working hard to build a safer New Zealand. And in fact, this bill that is being proposed is a bill that is a late starter in a race that has already been run and is over. The Anti-Money Laundering and Countering Financing of Terrorism Act 2009 already puts enhanced obligations on casinos to detect and deter money laundering, and already has enforcement mechanisms. This bill comes into force in July 2013. It comes into force in July 2013. And we also know that the Criminal Proceeds Recovery Act 2009 already contains a civil forfeiture regime, and a profit forfeiture order may be made by a court if it is satisfied a person has knowingly derived benefit from significant criminal activity. And so much of this member's bill is nefarious, and so much is, for example, should have known. Should have known. And other wordings on in the bill, derived or likely to be derived. Likely to be derived. How is one should have known, and how is it to be defined that it is likely to be derived? And so what we have here is, I think, very poor drafting in a bill that has no doubt some good intent, but its application and its outworking is fraught with great difficulty. So, Mr. Speaker, there are a number of good reasons why we don't support this bill. Now, we understand that money laundering involves transforming money from crime, and it is called dirty money. And if we are talking about anything that is dirty, that's where it comes from, is money from crime. And it has the appearance of coming from a legitimate source, and it makes the criminal origin of that money difficult to trace. It's therefore deemed as clean money, so that's where the laundering component or understanding comes from. And we understand that effective money laundering enables criminals to remove themselves from their criminal activities, and it makes it harder to prosecute them and confiscate their proceeds. We understand these difficulties. This is what governments over the years have always grappled with, and we believe that we have instituted a law that is going to take effect shortly, that is going to work very, very strongly to stop that. Mr. Speaker, this bill will amend or would amend the Act to apply the profit forfeiture regime to casinos who benefit from significant criminal activity and either knew or should have known. Now, how does one should have known? How do you determine that they should have known? And that the benefit is derived or likely to be derived from criminal activity. So key issues the bill tries to address are returning proceeds to people from whom they were acquired or stolen. Now, I understand that there's good intent in wanting to see that happen, but I would say that a majority of people who have an item stolen, whether that be in cash or whether that be in property, most people would have that insured, and most people would receive some benefit from an insurance policy. And yet they are going to receive, under this bill, the cash return or the value return if somehow the proceeds of those funds are deemed to be received by a casino. I'm not quite sure how that would happen, in fact. There's not many criminals out there who carry a receipt book, who actually write down exactly where and when and how they have been able to arrive to their proceeds of crime amount, whether that's $1,000, $10,000, $20,000 or whatever. And so somebody might take a stash of cash, a handful of money into a casino and gamble it, and perhaps by international best practice, by observation and technology and technique, somebody could, or a system could discern that this person has peculiar activities that could profile them as a person that ought not to have such a large amount of money, or has come here time and again with a large amount of money, and could start to identify that person as a person of suspect. How would you then go and determine that that person may have received that money through an act of crime? We're starting to delve into the area of guessing and double guessing and not be sure about these things. And I think that our laws need to be better constructed and stronger in regard to these assets, or these issues, rather. And so, in terms of the assets recovered under the Act's civil forfeiture regime, they are not returned to those persons from whom they have been stolen or acquired. They are returned to the Crown. That is simple, that is not complicated, and there are other mechanisms in which a person who has suffered loss can recover that loss. Also, there are lowered thresholds of liability for casinos. There is no reason why a casino that knowingly profits from significant criminal activity cannot be the subject of a profit forfeiture order under the Act currently. The bill effectively imposes a lower threshold of liability on casinos by the statement "who should have known," compared with other persons who knowingly. And I think that this is an area which I feel very uncomfortable about, and I think that many people in this House would feel uncomfortable about as well. There's no clear evidence that casinos currently are not taking reasonable care to detect problem gambling and criminal activity. So this bill doesn't appear to achieve its aims of encouraging best practice or returning proceeds of crime to those from whom the proceeds were acquired or stolen. I believe that the Anti-Money Laundering and Countering Financing of Terrorism Act 2009, places enhanced obligations on casinos to detect and deter money laundering, and contains enforcement mechanisms that will achieve much of what this bill intends. So, as I said earlier, Mr. Speaker, that this bill is a late starter in a race that is already run and is over. Thank you, sir.
I call the honourable member Charles Chauvel.
Thank you, Mr. Speaker.